If you get a divorce, but everything is in your name, all the property that is, do you get to keep everything, or do you have to split it with your spouse? I will answer your question in the context of the law of the jurisdiction where I practice divorce law, which is Utah. First, a short answer to your question. Whether property acquired in the individual name of a spouse during a marriage, other than by gift or inheritance, does not somehow shield that property from being awarded in whole or in part to the other spouse in divorce. Second, it will be helpful to understand a few terms that are key to understanding property in divorce. I'm taking these from Black's Law Dictionary, 11th edition, that was published in 2019. First, marital property. That's property that is acquired during the marriage and that is subject to distribution or division at the time of marital dissolution. Generally, it is property acquired after the date of the marriage and before a spouse files for separation or divorce. The phrase marital property is used in equitable distribution states and is roughly equivalent to community property. Don't worry, we'll get to those definitions in just a bit. Separate property. That's property that a spouse owned before marriage or acquired during marriage by inheritance or gift from a third party, and in some states it's property acquired during marriage but after the spouses have entered into a separation agreement and have begun living apart or after one spouse has commenced a divorce action. Community property. Those are assets owned in common by husband and wife as a result of their having been acquired during the marriage by means other than an inheritance or a gift or devise to one spouse, each spouse generally holding a 1/2 interest in the property. Only 9 states have community property systems: Arizona, California, Idaho, Louisiana, Nevada, New Mexico, Texas, Washington, and Wisconsin. Community property regime is elective in Alaska. Equitable distribution, also known as equitable division, means the division of marital property by a court in a divorce proceeding under statutory guidelines that provide for a fair but not necessarily equal allocation of the property between the spouses, as would be the case with community property. With equitable distribution, when a marriage ends in divorce, property acquired during the marriage is divided equitably between the spouses and regardless of who holds title to the property. The courts consider many factors in awarding property, including a spouse's monetary contributions, non-monetary assistance to a spouse's career or earning potential, the efforts of each spouse during the marriage, and the length of the marriage. The court may take into account the relative earning capacity of spouses and the fault of either spouse. Utah is an equitable distribution state in the context of divorce. Here is how Utah defines the difference between separate and marital property and what a divorce court is empowered to do with separate and marital property in divorce. See the case of Lindsey v. Lindsey, 392 Pacific 3rd Reporter, page 968, from the Utah Court of Appeals in 2017. That decision states in part, when distributing marital property in a divorce proceeding, the overriding consideration is that the ultimate division be equitable, that property be fairly divided between the parties. To that end, a trial court must first identify the property in dispute and determine whether it is marital or separate. Marital property ordinarily includes all property acquired during marriage whenever obtained and from whatever source derived. Separate property ordinarily includes premarital property, gifts, and inheritance during the marriage, including any appreciation that may accrue during the marriage. The presumption is that marital property will be divided equally, while separate property will not be divided at all. Married persons have a right to separately own and enjoy property, and that does not dissipate upon divorce. Thus, equity generally requires that each party retain the separate property he or she brought into the marriage, including any appreciation thereof. But separate property, quote, is not totally beyond a court's reach, close quote. That's from an actual case. Before carving property out of the marital estate, a trial court must consider whether circumstances warrant an equitable override of the separate property retention rule. 3 circumstances have been identified under Utah law as supporting an award of separate property to the other spouse at the time of divorce. These exceptions are when separate property has been commingled. That means it went from being separate property to jointly owned or held property, or when the other spouse has augmented, maintained, or protected the separate property, and in extraordinary situations when equity so demands.